Hi guys, AJ here coming at you with some more IP, and this week is week 7, so we're more than halfway through the unit. I don't want to say a whole lot, and you're probably inwardly going, yay, about IP reform this week because it's obviously topic number 2 for the end of semester paper. So with that in mind, we need to still do a little bit of a look at what reforms are being suggested right now and how we think they're going to be received out there in Australian society. So first and foremost, we're here at the Productivity Commission report website. This is the granddaddy of all reports that's been done for some time. It's ambit is necessarily broad. It purports to cover pretty much all the IP rights, as well as competition issues, in an attempt to get some kind of overarching policy direction for intellectual property rights in Australia. The government response to the competition policy review that we looked at a couple of weeks ago has been put on hold until the government responds to this particular inquiry report. As you can see there, the report was finished in September 2016, and then it was obviously issued to all of the head honchos in the relevant departments. And it was finally released to the public in December 2016, just a day or two before everyone went on their Christmas break.
It's beginning to look a lot like Christmas.
Some rather cynical commentators have mused about the timing of this particular report and whether it was intended to be buried in the Christmas holidays. I think that there is enough in this report to annoy various interest lobby groups that the report itself was never going to actually just quietly fade into oblivion. Whether it actually achieves anything is yet to be seen, because, as I said, the government response isn't due until mid this year. You will note when you read the overview and recommendations, for those of you that are not doing topic 2 for your end of semester paper, I wouldn't bother about reading the entire report. It's many hundreds of pages, and you've probably got more sleep to catch up on than time to read this stuff. But the overview and recommendations I would heartily recommend everyone reading. Firstly, to kind of set the scene, the Productivity Commission goes through, what are the justifications for IP, and they go about discussing the ones that we've looked at in week 1. So it's to secure a sufficient return on investment for creators.
Show you the money. Not show you. Show me the money.
It corrects the public good nature of intellectual property rights. Remember, we talked about public goods in week 1, and there's a nice little quote in the report from Thomas Jefferson that kind of encapsulates this quite well. He says, "As he who lights his taper at mine receives light without darkening mine." So you can see, 2 people, one has a candle, the other one has a stick of wood. The person with the candle lets the person with the stick of wood light their taper, and hey presto, you've got 2 flames now, not 1, and the original flame is still going strong, hasn't been, in Thomas Jefferson's words, darkened, and both are free to use that flame however they see fit.
Thomas Jefferson, you are as great a wit as you are a statesman.
So that's a little bit like intellectual property rights. We know all about that justification from our reading in chapter 1 of the Fitzgerald text. The third justification they go through is providing social and economic value to extend the frontier of knowledge.
We're going to a new frontier.
And this is the fostering innovation kind of argument that you see often related to increased patent rights. They go through a number of these justifications, and they say that all sounds well and good, but if you get the balance wrong, if you don't balance the needs of creators and the downstream needs of users, then you risk damage being done, not only to society, but to innovation in particular. And they say you can get things like undue exercise of market power. We had a little look at that when we were looking at the Competition and Consumer Act. They also mention Australian being a net importer of IP, and I did actually mention this way back in week 1. The problem with Australia being a net importer of IP means that the costs to Australians of purchasing works or innovations that are protected by IP rights can be higher than they would otherwise. And that's not necessarily such a good thing for our economy. So they say, looking at all of these things, all of these balls up in the air, what is the policy imperative for IP rights? And they give a nice little summary by saying you've got to find this magical balance between incentives to create on the one hand and the risk of damaging the use of new ideas. This is the downstream issue, risk of damaging the downstream use of new ideas due to overprotection. And they said over all of these discussions, you have to overlay the consideration that Australia doesn't operate in a vacuum. We're part of a global society. We have a number of different international treaties that we need to comply with. And so we're not just free to choose whatever policies seem best to us. We, at all times, need to make sure that we are doing the right thing as per our international conventions. So they say, well, what are some principles that we might be able to find, some broad-based, rather general principles that will serve to pull a thread through Australian policy on IP and give it some kind of consistency, some benchmarks that might assist when we are looking at tinkering around with the IP rights that we have on the books at the moment. And they talk about 4 policy principles. IP policy needs to be effective, so it has to encourage and incentivise. That's probably the main reason for having IP rights. It has to be efficient. That is, the incentives that we just talked about have to be achieved at the lowest cost to the Australian economy and our society. They need to be adaptable to economic change, and they need to be accountable. So they need to be evidence-based, transparent, and finally they mention it, they have to reflect community values. And here I think is the rub of the difficulty faced by the Productivity Commission. As much as the report tends to focus on hard dollar figures to kind of paint an exclamation point about why we should or shouldn't be introducing reforms into the various different IP rights, and they say necessarily, principle number 4, we need to keep our IP policy accountable. You've got to have lots of evidence. Hard evidence is always good. It has to be transparent, and you can see just the hallmarks of the economic influences of the Productivity Commission coming in here. But community values is really the, I'm not going to say sticking point, perhaps bugbear in the whole question around whether or not these recommendations are going to be accepted. And what community values will prevail in all of this, we don't know. Certainly there has been a loud cry, a deafening cry by copyright creators, screenwriters, authors, musicians, in decrying the reform of copyright in the manner that's been suggested by the Productivity Commission, and in particular the fair use rights. But then equally you have academics, you have commentators weighing in on the opposite side of the social debate, saying, well, hang on a minute, we've still got parallel importation restrictions for books. How can this be? You know, why can't Australian booksellers source their copyrighted books from overseas if they're more cheap than the ones on offer here? Bring them over to Australia, let the Australian public sort it out. If they want the cheapest item, you know, they should be able to select from their local bookseller the cheapest item that they can. But at the present point, they can't. Whilst you can buy cheaper books overseas on Amazon as a personal consumer, booksellers aren't allowed to take advantage of the same kinds of systems. It kind of seems a bit crazy, but you have this very heated debate. And I think in part that the debate is just so heated because, particularly in the area of copyright, you have the creators viewing their intellectual property rights very personally and in a very, I hesitate to say, but emotional fashion. When you have gone to such lengths, can be days, months, weeks, years, in creating something like a novel, I'm sure that at the end of that process, you feel that, you know, a copyright is insufficient as it stands, and perhaps there needs to be perpetual copyright protection. On the other hand, you know, the people that want to buy the books, well, you know, you do really want to get that cheap book if you can. So debate has been polarised. I've got a few snippets of articles in the resources for you to explore. Because of the polarised debate, I'm not really sure how the government is going to go in terms of its response by mid-year. And we'll just wait and see as to how far these recommendations go towards being implemented. Turning to the actual recommendations themselves, for copyright, they do make mention that they think that the term of 70 years is probably a little excessive. However, they also recognise that we have international obligations that require us to provide that term. And they just suggest in a rather oblique fashion to kind of work with other countries in sorting this issue out. They don't actually make a recommendation on term. So some of the articles that you see by copyright lobbyists maintaining that they're suggesting or recommending a 25-year term is not correct. They actually don't make a recommendation on this issue, so that one's a bit of a furphy. The big ticket item, and the one that really is put the cat amongst the pigeons, is the fair use, fair dealing argument. And obviously there's going to be a presentation on this, and I suspect there will also be a fair bit of commentary on this for the end of term paper. So I'm not going to say a whole lot about that. If you're not doing fair dealing or fair use, or even if you are, I probably would recommend the video that I've put up in the week 8 readings that deals with fair use and fair dealing. It sets out the position quite well in quite a nice humorous fashion. They also talk about geo-blocking, which is the use of technological constraints to allow, for example, large movie houses to release one version of the movie for Australian audiences, another for America, another for Europe, and so on. And by subdividing the release of the movie by territory, they can maintain differential pricing for each of the territories. Now, people have been able to get around this kind of stuff for years. The question has been, what do we do about it? They talk about geo-blocking there. Parallel importation of books we've already briefly touched on. And that's the suite of recommendations for copyright. For patents, it's rather an interesting set of recommendations they have made. They do whinge that there are too many low-value patents on the books, and that drives a number of their recommendations. The first one is that they think that the Patents Act should have an objects clause. And if you remember back to your statutory interpretation days, these will assist the courts when they are interpreting the legislation. And they say that the objects clause should touch on issues like the legislation is intended to enhance the well-being of Australians by promoting technological innovation and by promoting transfer and dissemination of technology. Now, if you think that sounds terribly inspired, it's actually not. It's pretty much a rip-off of Article 7 of the TRIPS Agreement. And I did briefly want to mention the TRIPS Agreement for you. Because it was probably mentioned in week 1 in the text readings. I'm not sure how many people managed to get across that, but here we have the TRIPS agreement, and interestingly, this is pretty much the preeminent international treaty that many hundreds of countries are signatories to. If you look down, it actually mentions the international agreements, the big ticket international agreements that most of the members to TRIPS are also members of. So you'll see the Paris Convention, that was the 1883 convention dealing with industrial property, what they used to call industrial property, so that's patents and trademarks. The Berne Convention also, I think it was 1883, dealing with copyright. The Rome Convention, and that one is for performers and phonograph producers as well as broadcasters, and also the Treaty on IP in respect of integrated circuits. They are the big ticket ones, as I said, and the Paris Convention, Berne Convention, Rome Convention really are all designed to foster an atmosphere of international cooperation when it comes to the issue of protection of IP rights. So if you're interested in those conventions, have a little look at the text. The text does mention them, or just have a Google and see if you can find out what they're all about. But certainly those are the main ones that you need to worry about. Article 7, as I said to you, was the inspiration for the Productivity Commission's suggested objects clause, and you can see here, the protection and enforcement of IP rights should contribute to the promotion of technological innovation and the transfer and dissemination of technology to the mutual advantage of producers and users, and in a manner conducive to social and economic welfare and a balance of rights and obligations. So, very nice inspiration there, perhaps easier said than done. The second thing that they recommend is raising the threshold of inventiveness yet again. It was raised under the Raising the Bar Act by tinkering around with the definitions of it was prior art and common general knowledge, increasing the pool of information out there that could add up to the person skilled in the art thinking that your invention was obvious and therefore didn't have enough inventive step. What the Productivity Commission recommend is now tinkering with this idea of obviousness. Currently, we only require what they call a scintilla of invention. they suggest that that's really not sufficient any longer, and we need to make inventive step higher so that only significantly inventive inventions are patented. Only the really inventive stuff makes it onto the books. So that's their suggested reform in the area of inventive step. They make a number of other recommendations for patents. Some of them are more technical in relation to fees, in relation to the kinds of things that need to go into claims, software patents. But the two big other ones that I wanted to draw to your attention was the suggested removal of the second tier patent system. And this would entail pretty much throwing out the entire system of what used to be called petty patents and now are called innovation patents. We have had some discussion about this in the forums. I'm not necessarily sure that that would fix a whole lot of the ills that are currently present in the patent system. They also recommend throwing out the extensions of term for pharmaceuticals.
Great Scott! Great Scott! I know, this is heavy.
And that one will certainly be hotly debated. I'm sure that there are lobbyists hot on the heels of the government decision makers here against that particular suggested reform. So that's all I really wanted to say about patents. In relation to trademarks, really they're just kind of tinkering around the edges. There's not a whole lot there to get us too excited. They're saying that you need to use your trademark within 3 years rather than 5. They're saying things like, we've got to be careful with use of geographic locations that might give a mistaken impression of quality or so forth. They do suggest linking the business names register and the trademarks register so that you might be alerted if someone's trying to register a business name that might conflict or infringe on your trademark. I've read some commentary on this that it's probably just going to confuse people more because you can understand you're only going to be able to sue for infringement if the other person is using your mark on the same kinds of goods or services that you've got your mark registered for. So, that's a well-intentioned reform. I'm not sure that it will achieve what it sets out to achieve. It does confirm that we need to remove Section 51(3) of the Competition and Consumer Act. And there are various other reforms in general terms that get made. I certainly hope that the government thinks long and hard about the reforms that are suggested here. I think there is certainly some merit in some of the recommendations, and if we can get some of them across the line, I guess it's probably better than nothing. But more than anything, I think what we do need to think about is what the Productivity Commission mentioned at the very beginning of the report, and that is we need to have some kind of centralised consideration of IP policy, because there has been an inordinate number of amending legislation, going out to each of the different IP rights, and an enormous number of, inquiries, reports from, the Australian Council on IP, so ASIP, the CLRC, the ALRC, and a ragtag bunch of other reform interested bodies. At last count, there was about 29 different inquiries that have been held in recent times. The amounts of amendments to legislation, I stopped counting in the text at about 15 pieces of amending legislation. We really do need to get a handle on the whole notion of IP rights and deal with it as a body in a collective sense. I think that what Australia is crying out for is that centralised IP policy, interdepartmental committee. So have a look at the report. I think it's certainly food for thought. And that's pretty much all I wanted to say on it. Like I always say, if you have any problems or queries, please shoot me an email or a tweet or post up something in the forums and we can have a chat. Other than that, if you like this video, give it a big thumbs up and subscribe, and hopefully I'll get to talk with you in a Zoom sometime soon. Other than that, thanks for watching. Bye guys.